SJC-12984, Commonwealth versus Julian L. Troche.
Okay, Attorney Shaw.
Chief Justice Budd, and may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Julian Troche. My intention this morning is to begin with the Fifth Amendment issue, to address the Facebook messages issue, and then to touch on gang evidence and related issues that we assert are part of a larger pattern of prosecutorial overreach. With respect to the Fifth Amendment issue, I'd like to first be very clear about what happened that comprises error. It is beyond any reasoned dispute in this case that the prosecutor knew when Mr. Woods, the witness, was subpoenaed to appear a week before he actually testified that he did appear, that he consulted with legal counsel, and that he invoked his Fifth Amendment right to remain silent. The prosecutor knew that invocation was deemed valid by a judicial ruling after a Martin hearing, after which Mr. Woods was granted immunity. And when Mr. Woods testified a week later, the prosecutor wanted him to testify in a manner that implicated Mr. Troche, namely that he, Woods, was part of a scheme with Mr. Troche to identify who had shot his son, that he personally sent Mr. Troche a picture, that he knew retaliation was going to take place, and that he communicated with Mr. Troche about it on November 12th. And all of that is fine. The critical error in the case occurred when the prosecutor didn't hear the testimony that he wanted to hear.
Mr. Shaw, the prosecutor, and this is a question, not a statement, the prosecutor would be able to explore Mr. Woods Sr.'s understanding of the scope of his immunity, correct?
I think that it was fair game for the prosecutor to, with respect to immunity, to clarify and ensure that he understood that he could be prosecuted under the immunity agreement.
Right, because if his understanding is, well, I'm immunized, I can say whatever I want.
Oh, right, sure.
Could say, well, there are limits to this, right?
Yes,
and I think that's fair game.
I think that that's fair game with respect to immunity. The problem here occurs because immunity was intertwined with the Fifth Amendment invocation. And what the prosecutor did here is he made a choice to attack Woods in front of the jury in a calculated manner by eliciting, you were subpoenaed a week earlier, you showed up, didn't you?
But part and parcel of saying to the witness you were immunized is the fact that they invoked, correct?
Sure.
Because I know the old law, and I forget the name of the case,
yes,
is that you can't call someone to the witness stand
right.
to make them invoke in front of the jury. That's prohibited.
Well, that's right, and you're also not permitted to ask the jury or conduct your examination in a way that you're asking the jury to draw an adverse inference against the witness because they've invoked.
So if you have this examination that we said you agree is proper, the bounds of the scope of immunity. In setting that up, is it permissible, well, I guess you're going to answer this, but is it permissible for the prosecutor to say, here are the steps. You showed up, you asserted the Fifth, you were granted immunity. Now let's talk about the scope of immunity.
No, it's not. The jury isn't aware about, and the jury isn't focused on this person, consulted an attorney, and that's what the prosecutor did. He said, you've been subpoenaed, you showed up weak, and then he emphasizes, you showed up with an attorney, and then he emphasizes, you refused to testify, and then he emphasizes through his questioning, he elicits the fact that he invoked his Fifth Amendment privilege.
Is there any case law, and I've of course read the briefs, but that deals with, we have the end result, exploring the scope of immunity, but the foundational questions that you say are problematic, are there cases that address those foundational questions?
I believe there are. I think the state and federal cases both hold two things very clearly. First, seeking to have the jury draw an adverse inference against a witness because they relied on their constitutional rights or invoked is improper. And second, that it will have a strong and illegitimate impact on jurors because they will view it as a confession. The problem here is that what the prosecutor did was obviously done for purposes of conveying to the jury that they should not believe Woods, that Woods did these things because he wanted to hide his participation with Mr. Troche, And that in turn shows that Mr. Troche is guilty, and he then emphasized this again in closing argument. So
Those two points from the federal and state authorities, they don't answer Justice Gaziano's question about cases regarding the foundational questions, because the reason there is an immunity is because of the Fifth Amendment privilege, so there is necessarily a nexus, but you're not aware of any cases that explore how far a prosecutor can go in terms of asking questions about the foundation of the immunity.
Well, I am, Your Honor, because I think...
What are those cases, then?
Well, there's Gagnon. These are state cases, Commonwealth versus Gagnon, Commonwealth versus Martin, Commonwealth versus Rosario, all cited in my brief. Federal cases, you have Grunwald versus United States, U.S. Supreme Court granted a new trial. That was simply because it was brought out on examination that there was an invocation before the grand jury. Nemeth, and then I've cited multiple cases in the federal and other state courts that result in reversal because that was done. I guess what I'm disagreeing with is the notion that these are just foundational questions. I think the court needs to focus on what the jury understands. The jury can understand that this person has been granted immunity, but that doesn't mean that we go into the fact that they showed up with an attorney, they refused to testify, they invoked their right to remain silent. Those things, that's not necessary at all. And in the typical case, when we're dealing with a witness who has been granted immunity, there's a very basic instruction which simply says, this witness has been granted immunity. You can take that into account and consider whether they were offered any promises by the government. Now,
because I've heard those foundational questions in court a number of times. Mm-hmm. Maybe I asked them, but I've heard those. But I know defense attorneys often do this to witnesses. They'll say, you know, you consulted with a lawyer, you asserted the Fifth, you've been immunized by this government. You know, that's where you usually hear it is from defense counsel.
Well, first, that's not my experience. I think it's contrary to the case law. And I think that in terms of a defendant is in somewhat of a different position.
I get your point that we hear immunity and we think Fifth Amendment.
Right.
And we fill in the blank, and a juror may not do that, so there's no need for those foundational questions.
Right. And you have to look at what the prosecutor was doing here. In this case, both of the factors favoring reversal in the case law are present. First, we have intentional tactic by the prosecutor, which under the case law is itself alone sufficient to cause reversal. Second, an alternative basis for reversal exists if the impression created by the prosecutor added meaningful weight to a guilty verdict. And that is also true here because we have Woods, who is a witness, whose relationship to Troche is alleged to have revolved around and been a part of the same criminal involvement for which Troche is on trial. So there's a high likelihood that the jury not only inferred the guilt of Woods, but inferred the guilt of Mr. Troche. And then in this case, we have additional factors that exacerbated the prejudice. There was no jury instruction to address the prosecutor's tactic. There was no jury instruction to ensure that no inference could be drawn against Mr. Troche. The prosecutor's tactic was insulated because defense counsel was not permitted to also address the same subject matter. He tried. The prosecutor objected, and the judge sustained the objection.
Did Attorney Greenberg say anything when the prosecutor asked about consulting with the lawyer to say, wait, that's out of bounds? Did he object to that question?
He was objecting, yes. I believe he objected pretty clearly, and then the judge actually intervened and said, you can't do that. Okay, so the judge was very explicit. The issue was known by everybody involved.
Right, so the judge sustained the objection.
Essentially, yes. He told the prosecutor, you can't do that, move on. And then the prosecutor returned again to the subject matter and emphasized again, you refused to testify.
And the judge sustained the objection?
Yes.
Isn't that a problem for you?
Well, it's not because this is focused on the prosecutor's conduct and the fact that this came in and it never should have come in. I mean,
how does it come in if it was objected to and sustained?
Well, because because the prosecutor kept returning to it, and you'll see that in the progression of the
You're not
question.
really into that question. So if we have a lot of cases that say if an objection is sustained, the evidence is stricken,
The evidence was not stricken.
well, objection sustained, and the judge says, anything I sustained, you can't consider. That's, right, that happened?
He did not say anything you can't consider. Yes. And you,
Whoa,
I think,
wait a minute. In the beginning of the trial, the judge didn't say, this is how it's going to work. If there are objections,
I don't recall that specifically, Your Honor, but I'm talking about this particular progression of questioning. I think you'll see that this was persistently focused on by the prosecutor, even after the judge had told him not to do it, okay? And I think an additional reason that prejudice was exacerbated is that the judge further instructed the jury in a manner that emphasized that was consulted with an attorney and then he refused to testify when he was addressing immunity. That is not part of the typical immunity instruction. So with respect to the
What do we do with the fact that there was no objection to that instruction?
Well, there wasn't an objection to that instruction, that's true.
Well, yeah, I know that, but the question is, how does that affect, the review that we give at this point on appeal?
Well, I think that the fact that that instruction was given exacerbated the prejudice, and I think that was an error, and I think that should be considered in combination with the objections that were made by defense counsel on this general subject matter. Now, with respect to the Facebook messages issue, this issue is grounded in unfair process. When these messages came to light, there was no way to meaningfully evaluate the credibility and the authenticity of the messages based on the messages alone. And that is precisely why the judge had this ongoing concern over a matter of days. More information was required, and he knew that. And the problem here is the way he went about acquiring that information. He relied on one side in an adversarial proceeding to gather information outside of court in what was a private and untransparent setting that, if pursued, would undermine the prosecutor's own witness and their case, and legally the prosecution had no obligation to follow through
What
on
did
the
the
judge's
defense attorney
request.
do during those couple of days when the Commonwealth was trying to track it down?
Well, he didn't, well, I mean, the trial proceeded. The judge at the outset would not allow any delay, and so the trial proceeded. But he objected clearly on the record when...
Didn't do anything to
Well,
try
I
to track
mean,
it
Your
down?
Honor, he's in the middle of trial.
Oh, I understand that. I get trials tough.
Yeah, and so he's
have
objecting
an
on the
investigator?
record to not allowing, not bringing Rodriguez in for a voir dire.
Okay.
And then you have the judge who is essentially relying on the prosecutor's own characterization of a private conversation with the witness, who, of course, had every incentive to adamantly deny that he had been influenced by anybody or had lied when he testified. So that is clearly an unfair process, and it's an unfair process because it excluded the defendant's presence. It deprived the defense of an opportunity to examine the witness, and it resulted in an arbitrary ruling without an adequate means to evaluate the credibility of Rodriguez or to the authenticity of the messages. And then in this case, there are a number of things that happened that make very clear that this was an erroneous and arbitrary ruling. The judge wouldn't allow a voir dire of Rodriguez based on the notion that he would have to close the courtroom, which he acknowledged under this court's precedent he could not do. So that made absolutely no sense. It obviously wasn't necessary if it wasn't permitted under law. Second, he concluded that placing Rodriguez under oath would make no difference. That is inconsistent with the principles that underlie our judicial system. It does make a difference when we place people under oath. Third, he assumed that Rodriguez would simply say the same thing that he said to the prosecutor in a private conversation. That is entirely speculative. he assumed that there were unspecified dangers that were fraught in his language in bringing Rodriguez in, and there was no basis in the record for that. And finally, he concluded that no cross-examination could occur without the information from Facebook. That also was not supported by the record. So this was
So the defense attorney could have taken the screenshots and cross-examined Rodriguez, is your position?
Sure. He could have asked him about, confirmed, do you have a Facebook account? Is it active? He probably could have pulled a profile at that point, profile picture, and asked him. He could have questioned him about whether he had contact with others and messaged other people through Facebook. Probably could have asked him about his family members and who may have actually provided the text messages and things of that sort.
So let's say this was a mistake, an error, an abuse of discretion.
Yes.
Which is a high bar for you. But assuming it is new trial, what's the basis for
I
that?
think there should be a new trial.
Well, of course, but what is the basis for it?
Well, I would point you to the Stuckich case. There we have a similar situation. We have a factual conflict. This court ruled that it was improper to rely on the prosecutor's word alone. The judge was unable to rely on the documentation alone.
But I thought Rodriguez's testimony was maybe not entirely duplicative, but somewhat repetitive of the other gentleman who was washing the car with him that day.
I don't think that's true, Your Honor.
Okay,
think
so
you
if I
the-
look at it, it
I
turns
think
out
that's right.
Rodriguez was more
I think that
important
it
and
was-
critical.
I think so. I think so.
Which
I
one
don't
was the
think-
ID witness?
Excuse me?
Which one was the identification witness?
That was Rodriguez. And the identification took place 6 months after the incident in a procedure that, in 2016.
But correct if I'm wrong, there were two people out there washing the vehicle,
Right.
right? And one does the photo ID.
That's correct. 6 months later.
That was
and-
Rodriguez.
And that was Rodriguez, right. And of course, that wasn't at the scene. At the scene, there was one person who said that there was a car similar to Rodriguez's mother's, but she couldn't say whether it was the same vehicle. There was a second person, witness, Sheila Klebus, who testified that the car was dark blue or black, which was consistent with the picture that the defense attorney had shown. So moving on quickly to the gang evidence, we're asking the court to consider this issue and its impact in combination with the larger pattern of prosecutorial overreach, which includes not just the Fifth Amendment issue, but inflammatory evidence pertaining to the September 17th shooting and the arrest of Mr. Troche. This court has made very clear that gang evidence has a high risk of prejudice and that foundation needs to be established. Basic foundational facts: is Mr. Troche a gang member? Is this incident part of a feud that pertains to the gangs? Is the information that's being received coming from reliable sources? Is it ripe? Is it stale? And of course, if an officer is called under 702, those same elements are required: sufficient facts or data, reliable principles and methodologies, and information that will assist the trier of fact. Now, in this case, defense counsel objected to the gang evidence. He was adamant that Mr. Troche was not a gang member. The prosecutor knew that, but he sidestepped any foundational requirements and blanketed the case with gang evidence through the back door. He never established that Mr. Troche was a gang member. He never connected the shooting to a particular feud, but he repeatedly referenced gangs, gang violence.
He did connect it to a feud.
Excuse me?
He did connect it to a feud.
Well, Your Honor, he elicited testimony without first doing it outside the presence of the jury that there had been these two groups and conflict that had occurred. But we're talking about a time period of, I think, 20 plus years.
So we have the September
Shooting.
Well, that's a single incident.
Well, you also
Well,
have.
it's kind of a feud, isn't it?
Sure, and you also have Wood Senior's testimony.
Excuse me?
You also have Wood Senior's testimony.
You do have Wood Senior's testimony, yes.
So again, there was evidence of a territorial feud.
Well, again, I mean, territorial, I think, and what the Commonwealth is claiming is that this was personal retaliation and a personal incident, and that's why they're trying to distinguish it from the gang evidence. But the gang evidence that came in,
Actually, I think that might be helpful to you. It's a personal feud, unconnected apparently to any gang-related activity.
well, sure, but but again, if you want to then,
No, I think it's helpful to you.
yeah, if you want to intermix it, yeah, with gang evidence and put them all together, the gang evidence is still highly prejudicial in that context. And so, you know, this was character and propensity evidence relative to Mr. Troche. And then you have to add that to the 35 photographs that were introduced relative to the September 17th shooting, 4 of which included a body lying in the street, 1 of which showed the victim lying in the street with a bullet hole in his head and brain matter and blood spread on the street. You've got to add that to, you know, this SWAT information, really just a big production about SWAT teams being called in. They're there for tactical duties, 4 SWAT vehicles, 4 different teams, specialized unit to conduct surveillance, to then seize him, to then take him to headquarters, and then a gun car after that. So this was all highly prejudicial. All of this operated as character and propensity evidence. Thank you.
Okay, thank you. Attorney Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth. I'm joined by the trial prosecutor, Mark Zanini. We're asking this court to affirm the convictions for the defendant's murder of Dantley Leonard and the shooting of Antoine Mayer. Beginning with the testimony of Woods Sr., as the court has asked, there don't appear to be cases that definitively delineate what questions can be asked when an order of immunity is happening with a witness on the stand.
But do you think you can ask a witness, you came here to court with your lawyer and you pleaded the 5th and you got immunity? Like, those are the fair game, is that
Yes,
your position?
certainly. I think that's important for the jury.
And then you can go back to it after you don't get the answer that you like, and you can say, again, you know, what's your understanding of immunity, even though the judge has already told you, stop.
And the judge had sustained that objection on the basis of it invading attorney-client privilege, which I also argue was incorrect. But in terms of Woods Sr.'s understanding of both his Fifth Amendment that existed before he was granted immunity and which ceased to exist after he granted immunity, was fair game. And for this proposition, I'd cite to Michel and Di Benedetto cases that I submitted through a 16L letter. Di Benedetto involves an immunized witness who had given conflicting versions of events, the final of which was the least damning to him and led to the order of immunity. And defense counsel was allowed to explore on cross-examination of that witness at what point in the case, in his recitation of these different versions of events, he was granted the order of immunity and what he understood it to mean. And though it's not a perfect analogy, most of these cases deal with cross-examination of a Commonwealth's witness versus direct. I think the underlying point and purpose of those questions being proper is similar. It's about assessing the witness's credibility, what they believed they were free from prosecution of when their Fifth Amendment was asserted, and what the Commonwealth was granting, essentially, in that order of immunity.
What does availing yourself of counsel have to do with any of that?
I believe it just has to go to the process in terms of the jury understanding what happened before the Commonwealth made this sought this extraordinary grant of immunity. And related to that question, I think Michel and Di Benedetto, as well as the other cases cited in my brief, are informative to the fact that him consulting with counsel isn't necessarily protected by any attorney-client privilege or the Fifth Amendment privilege. If he was being asked to explained to the jury the advice he had been given, that might be different, but even those cases say if it would have helped the jury understand his credibility, the attorney-client privilege would have ceded to that important trial goal. So here, what's being described by defense counsel as a prosecutorial tactic, I completely disagree with. They were proper questions, and as the court has already noted, no answers came into evidence. Essentially, this witness testified to evidence that was...
So
But
there
bef-
was an instruction at the beginning or at the end to say, you know, if there's an objection and I sustain it, you ignore the answer or the question? There was-
Absolutely, that it's not into evidence and questions are not evidence. The
But that
jury
was in,
instructed
that's
on
in,
that.
if I go back and look at the preliminary or the post instructions, I'll find that.
The jury was given that instruction, yes. If the court has no further questions about Wood Sr., I'll move to the issue of the Facebook messages. And I'd like to draw the court's attention to...
Because a lot of there's like 4 reasons the judge gives to not have a hearing.
Yes,
3 of them are just not are not sustainable. That we'd have to close the courtroom, etc. You know, as I read his explanations, I kind of shook my head on at least most of them. So other than it wouldn't do any good,
yes.
which is, I guess, all is what it comes down to in his view,
And
the
I think-
judge's view.
Sorry to interrupt. What I think is important about that when you're assessing whether or not this was an abuse of discretion is that the judge had information about Rodriguez, how Rodriguez comported himself in the courtroom, and his overall lack of cooperation with the Commonwealth. So when the judge saw these messages, and he said on page 5 of the 6th day of transcript, these appear to be an obstruction of justice, in the context of that statement, he wasn't saying that he believed Rodriguez to be obstructing justice. He believed these messages being disseminated to defense counsel on behalf of the defendant.
But that's an inference. So the judge never said, as part of my reasoning is I was able to assess he testified in front of me, not you, the SJC, in front of me. He never says that, though, right?
He doesn't say that explicitly. You're correct. He does speak to, though, the futility, or not the futility, what he believed to be the lack of import of bringing Rodriguez back to the
testified in
courtroom.
front of the judge goes into why he has an abuse of discretion, essentially, because he made the call, right? There's nothing magical about that. I'm just worried about an abuse of discretion where a lot of the things the judge said were just not true. I mean, closing the courtroom, you would concede, isn't an issue.
Right.
He shouldn't have used it. That's not a legitimate basis to deny.
Agreed.
Okay.
Agreed. I agree that he was listing reasons that don't necessarily bear on whether or not this was an abuse of discretion. But ultimately, I'd say it was not, because of both the judge's information that he had in the courtroom, his assessment of the reliability and the lack of evidentiary value that those messages had, and the fact that they were contradicting what he had viewed occur in the courtroom.
How can he make that assessment based upon just what the prosecutor tells him?
He took the prosecutor's, so actually, let me back up. The judge ordered the prosecutor to get in touch with Rodriguez and to get this information before the court.
No, he ordered him to get in touch with Rodriguez through detectives and ask if Rodriguez would allow access to his Facebook account. He did not order the prosecutor to ask Rodriguez, are these right? We've gotten these Facebook posts. Did you lie? Are you part of some sort of scheme? And have Rodriguez adamantly deny. He had sent the prosecutor off to conduct an ask of Rodriguez, can we look at your Facebook account, to shortcut the need to go to Facebook to get access.
And I certainly defer to the record of what the judge specifically asked the prosecutor to do, but the prosecutor was asked to get information and to bring it back before the court. I note that defense counsel agreed to this course of action. The judge was explicit at many points, asking both parties whether or not they had any other suggestions, saying he was open to another course of conduct. The defense counsel had no objection.
Defense counsel asked for a voir dire, and he said no.
Yes, and I meant that in reference specifically to the prosecutor calling Rodriguez or getting information from Rodriguez, nor did defense counsel ask to be a part of that phone call. But most importantly, the judge was taking the prosecutor's report of what happened during that phone call as an officer of the court. And in this context, I feel like that's especially, well, it's important in any context, of course, but here, the judge was giving that level of respect to the report of the prosecutor in the same way he was giving that level of respect to the report of defense counsel of how he came about these messages. So for it to be portrayed as if there was an unfair amount of credit being given to the prosecutor here because of their role of the government, I don't think is a fair assessment of how the judge took these
But the problem is not so much believing the prosecutor that he accurately reported what Rodriguez told him. The problem, I think, is not allowing anybody other than the prosecutor to ask Rodriguez
and
directly.
Your Honor's correct that the judge did deny the option of having a voir dire in court, but he did not deny the option of anyone else speaking to Rodriguez. Defense counsel did not pursue that information himself, did not ask for funds for an investigator to speak to Rodriguez or to Rodriguez family members that seemed to be alluded in these messages. There were certainly other avenues of investigation.
There are, but this is where I'm troubled. We all know that there is a difference between speaking to someone out of court versus speaking to somebody in court, in a seat, under oath or affirmation, with the judge sitting there with a robe and prosecutors and defense lawyers. It's very different. And considering that Rodriguez was the ID witness, I mean, in this kind of a case, understanding that abuse of discretion is a really high bar. And we've had cases before where we've talked about if a judge makes an evidentiary decision based on an erroneous understanding of the law, that's an abuse. And clearly in this case, there's a bunch of reasons that the judge gives that were just wrong. And so in light of all of that, is it not an abuse of discretion, or is the Commonwealth saying it's a prejudice issue, that there's no prejudice?
The Commonwealth is arguing that it was not an abuse of discretion.
How?
Because the judge, his resolution to this issue, which both involved asking, by my count, 8 different times for the parties to bring more information to him that might lend some sort of credibility to these messages. He said that he would revisit his ruling if that were the case. But for the judge to decide not to conduct a voir dire was not an abuse of discretion. And I distinguish from the cases that defense counsel has cited otherwise. I mean, beginning with Stuckich, that wasn't the judge abusing his discretion by not conducting a voir dire. That was a legal error about competing first complaint witnesses and anyone testifying to first complaint without that being legally vetted in a voir dire process. And Massey and Anguilo, I believe, are both about defendant's participation in a voir dire, not about a judge deciding whether or not to conduct a voir dire, but whether or not, or the ways in which a defendant's entitled to participate.
So let's assume that we think it's an abuse of discretion. What is the Commonwealth's response?
Well, preliminarily, I'd say that this isn't outside the range of reasonable alternatives, but if this court...
But no, yeah, let's just say
Yes.
we disagree with you, which is the definition of, yes, it's an
Yes.
abuse of discretion. I'm not saying that that's where we are. I'm just wanting
No, I
to give the
understand.
Commonwealth an opportunity to let us know why we shouldn't flip this.
Well, to turn to what prejudice that would have inflicted on the defendant, Rodriguez...
So the error is preserved.
Yes. Yes, it is.
So
And the substantial likelihood of a miscarriage of justice here,
not the standard because it's
I
preserved.
apologize. I
Yeah.
thought that's
It's
where
just
Your Honor was
it's
trying to
prejudicial error.
redirect me. The error here wouldn't have been prejudicial because Rodriguez had been on the stand, was subject to cross-examination, and as the judge correctly said, even if these Facebook messages had been in the hands of defense counsel when Rodriguez was on the stand, he would not have allowed him to cross-examine him about them because the indicia of authenticity and reliability was nil. Additionally, I'll leave it at that.
So he basically says these are in the same category as rumor, and I wouldn't allow rumor you be cross-examined by rumor.
Yes.
essentially.
Yes, I think that's a fair inference of how he rules. Additionally, I'd bring to the court's attention that, as the judge repeatedly mentioned, this was an issue that could have been, has not been pursued in a motion for a new trial setting. The judge said, should this result in a conviction, you certainly have newly discovered evidence, investigations that you can pursue. That was not done. That has not been pursued in any ways or means according to the docket or the Commonwealth's knowledge.
Would the judge said that at trial?
Yes.
Before the conviction, the
Before the
judge says, well, no harm, no foul, because if you get convicted, you can bring a motion for a new trial.
He doesn't say it in that way.
Well, I know.
Yes. No, I mean.
But essentially, he says,
He
listen,
says-
right now, you don't have time to go get a record subpoena to Facebook. They're going to fight it. That's going to take a while. If you get convicted, dear defendant, you can always bring a motion for a new trial, at which point you can call him in Facebook. Is that, you think that's within his discretion to have done that?
I don't think that informed his discretion in the way that I might have described it. What I think is that the judge, in his repeated calls to the party to bring additional information to his attention, should there be any, also said, this is my ruling at the time. I welcome more information. I'm open to suggestion. Should that not happen, there is this other avenue. And
Is that part
I
of our
invite you.
inquiry?
No.
When we assessed prejudice, we said, well, there was no motion for new trial.
No. If there are no further questions about the Facebook issue, I will.
Why keep saying SWAT? Why is SWAT relevant to anything?
So it was the officer's assignment at the time, and that was just factually correct, that's what his assignment was.
Well, a lot of
at the
things that
time.
are factually correct that are prejudicial, like you've been convicted 9 times of drunk driving.
Yes.
We don't allow factual, that's not the test. But like, why emphasize gun cars and SWAT to show the defendant is even more dangerous than the regular defendant?
And to be fair, I don't think it was emphasized. To the extent the officer testified that was his assignment at the time, and that was how they proceeded
Okay,
to calls.
I can get one time.
Sorry, okay.
I can get, all right. Who are you? I'm Officer Smith. Where are you assigned? I'm assigned to the SWAT team.
Yes.
What did you do?
Understood.
Then why instigate them? Why do we have this?
I would.
Counsel, can I dovetail off of Justice Gaziano's, could you answer a question for me, because I can get this from the record. When all of this testimony was coming in about the circumstances, was this all objected to?
No, it wasn't. And in fact, defense counsel stipulated to the fact that this arrest had nothing to do with the murder for which he was being tried.
So there was an objection to the SWAT multiple inferences, references, and that cut it off, right?
Yes.
Okay.
And also, I believe, no, I won't, I'm not positive about my memory of whether or not there was any sort of instruction given after that objection was
That's what I
sustained,
was. What I was getting at, because Justice Gaziano's question goes to relevance, but my question goes to the basis in the cure. So, if the objection was that it was irrelevant, or the objection was that the probative value was low and the risk of prejudice was super high, was there some kind of curative instruction or some kind of contemporaneous instruction by the judge?
And I apologize, I don't remember at that point how they had been instructed, but I do believe that in the stipulation that was read, the jury was told not to garner propensity evidence from this fact, just that was for them to know that it was unrelated. And I'd say that defense counsel had a strategic purpose in stipulating to that and potentially not objecting, and though I apologize for not remembering the record perfectly. This was helpful for the defense and helpful for their strategy in that there was seemingly an aura of excessive force, and a window was broken on this car, or there may have been overkill in the apprehension of him, for lack of a better word. Because the defense closing thematically centered around how the police, without good reason, focused on this defendant. And they had a narrow focus. The evidence did not bear out that he had anything to do with it, and that the car that he was arrested in that arrest that was described for the jury just simply was not the car that was on Ames Street when Mr. Leonard was killed. So there was value to the defense strategy there in terms of having this, a full description of the events surrounding the arrest and using it to his benefit to describe police overreach or
Can
miss.
I ask you to address the gang evidence?
Yes. What's most important about the gang evidence is that, or the gang evidence that did come before the jury, is that it never tied the defendant to gang membership.
Right, and I guess, yeah, that I think you're right. That is the key. Why did any of this gang evidence get in if there's no nexus to this case? It's entirely irrelevant and largely prejudicial.
It was relevant to many of the Commonwealth's witnesses.
That they
including
had
Woods-
20 years grown up in an area that might have been involved in territorial gang violence?
Yes, and that the Commonwealth's witnesses, the men who were present with Mr. Leonard and Mr. Mayer when they were shot, including Mr. Mayer, had been involved in gangs themselves. The Commonwealth, it was relevant for that evidence to be before the jury so that the Commonwealth could explain to them why these lifelong friends refused to speak to the police on scene after they saw their friend die, when they refused to speak to the police afterwards, and when they only participated with the Commonwealth when compelled to for grand jury subpoenas or for trial subpoenas. The testimony is clear from the record that these witnesses, I'd say especially Mr. Williams and Mr. Mayer, were openly hostile to the Commonwealth during their questioning. They were answering with one words, they were barely participating, and the Commonwealth was properly bringing that aspect of their background to the jury's attention to potentially explain why they weren't being cooperative or forthright. Also, there had been, as the court noted, the Commonwealth's theory of this case was the personal revenge. I say theory of the case, but I mean it more than that. That the defendant was seeking revenge for the shooting of himself and the killing of his friends, Wood Jr. As made clear in the motions in limine argument and the motions in limine brought before the court, there was a parallel theory that the Commonwealth was pursuing more directly related to the gang evidence, that when that evidence did not fully develop in the course of the trial, the Commonwealth properly and rightfully completely abandoned. And the fact that that evidence was underdeveloped before the jury doesn't mean that it improperly came in or that any of it prejudiced the defendant. In fact, I'd note for the court that the defense counsel never moved to strike any of the gang-related evidence after that other theory of the case was left underdeveloped. And he agreed with the judge that no evidence of the defendant's gang membership came into evidence, therefore there should not be an instruction. And the instructions that, a limiting instruction or a closing instruction from the cases that give exemplars, both would not have been appropriate for the jury, and if anything, would have potentially bolstered the credibility of Commonwealth's witnesses, which would have brought us before here on another issue. So in short, I'd say there were not errors at trial. There was not misconduct by the prosecutor. And lastly, I'd just like to urge this court that the defendant is not entitled to relief under 33E here. The evidence clearly showed that he stalked and hunted down someone to avenge for the shooting of himself and for Woods Jr. He shot Dantley Leonard 11 times, Mr. Mayer 3 times in the course of 6 seconds. And with that, the Commonwealth will rest on its brief.